SJC-12598, Frederick N. Halstrom, v. Marilyn P. Dube, and another.
Mr. Halstrom, still good morning.
Still morning, Your Honor. Thank you very much. May it please the court, the justices, Your Honor. My name is Fred Halstrom. I represent myself at this point in the case. I have a chosen action from my corporation. This is I'm not a witness in any of this except for the fact that Mr. Grace was my employee. This case involves legal fees, and I believe the court probably took this case on the issue whether or not when the statute of limitations runs on a contingent fee legal case. Plainly, if the court adopts the position of the court below, we've missed the statute of limitations against Mr. Dube. Now, Mr. Dube is represented by Mr. Grace. Mr. Grace is my ex-employee who did majority of the work on this case when this case was in my office. We alleged that we were entitled to recover either by contract or quantum merit for that time. That's what it says in my fee agreement. Mr. Grace is not only the key witness on the hours.
It's just not clear to me from reading all this stuff what's exactly at stake here. What are you looking for? Are you looking for attorney's fees?
Correct, Your Honor, and case costs, but
And
that's
how
in
much?
another case.
How much?
Well, that's a good question, Your Honor, because we don't know.
You don't know what you're looking for.
Well, on the record, we don't know what the case settled for, because in a companion case, Crico, the insurer, at the suggestion or after being given the alert by Mr. Grace, filed a motion to impound all of the settlement papers. They're all impounded to this very moment.
But you have acknowledged that the client, the now deceased client, has paid all the attorney's fees that the client can pay, right, under the statute?
I don't know, Your Honor.
I thought you said that at summary judgment to the judge.
The judge ruled that the statute...
But you said it at the oral argument to the judge that you're not looking for attorney's fees from the client anymore.
Right, because arguably, I hear, but it's not on the record, that the full attorney's fees were taken. I don't have any of those papers.
But assume that's true.
Yep. No, I'm looking for the fees I believe would come from the attorneys.
So you're looking for the fees to come from the attorney, from Mr. Grace?
And others that perhaps shared in that fee.
Okay, and the referral fee that went to Rubin and Redmond.
I believe that to be true, Your Honor, and to the firm that actually was the attorney on record on this case.
So what is it you're asking for from the estate?
At this point, there's no money left in the estate. Every cent has been paid out of the estate. That's why we've actually filed another action against Mr. Grace for the attorney's fees. We have a discovery case filed in 2015 trying to find out the hours spent, and we've taken Mr. Grace's deposition for at least a day and a half through about 8+ banker's boxes. When this case was in my office, it was actually on for trial. All work done, case ready for trial. That was in March of 2010, and then Mr. Dube, not Mr. Dube, Mr. Hicks went with Mr. Grace. That's a little bit confusing because according to the election letter that was sent to us, Mr. Grace was going to be the successor attorney, but he was not going to charge any case costs unless there was a successful recovery. But now we finally have, last year, we finally got a signed copy of the contingent fee agreement from Dana Pellegrino, which says the opposite. It says that Mr. Hicks is responsible for case costs regardless of the outcome, which is what our former fee agreement said. We also learned last year that all of the funds went to Dana Pellegrino because we finally got a copy of the check from Crico, which we say triggered the beginning of the running of the statute of limitations. Because until you find out how much money is involved, the fee...
But weren't you...
That's not what your contract says. Your contract just says that there's liability for $350 an hour for every hour that was worked before he left. It doesn't say anything at all about being limited by the recovery or by the settlement.
But that's the reason why, Your Honor, I believe this court is interested in this case, because it's a contingent fee matter.
Is it really, or is it converted into a contract matter as soon as
I don't think
terminated?
I don't think it is, Your Honor. This gentleman has no money. He knew that when he first came on board, so contract action against him would be fruitless.
But what's the point then of the $350 provision in your contract?
We have it in all cases, Your Honor. So that puts the successor counsel, counsel number 2, on alert as that there is counsel number 1, and that we have to be dealt with when there's a resolution of the case finally.
So you had claimed at one point you could not assert how much you were owed because you don't know how much time Mr. Grace spent?
Correct, he is resistant.
But it was your firm managing the case, wasn't it, up until he left?
Correct.
So why wouldn't you have known that?
Well, we didn't keep ours, and Mr.
Then how
Gray-
would you have enforced this in any event?
Well, we usually would have expected him to help us out as to what time he spent. He has the file. He took the whole file with him and resisted having his deposition taken.
Would still have to have made estimates. He wouldn't have been keeping a timesheet, right?
Well, he has testified, Your Honor, now for a day and a half in this discovery case, but some of the time he has testified to was like I believe he testified it took him an hour to prepare an appellate brief on an interlocutory appeal. Some of the testimony is frankly almost unbelievable, but that's it. So
That's not a good way to spend your time. Why don't you focus on the issue?
Yeah.
But if the contingent fees, the contract and the attorney leaves the firm, then you're on notice that you're entitled to the,
absolutely, Your Honor.
and that's the point in time in which the statute of limitations should run, isn't it?
But you, first of all, Your Honor, you have to know before you file anything, what is the amount involved? As Your Honor has pointed out, where's the money, what's the amount involved? This person is destitute, he doesn't have any money. So until there's a contingent recovery, which we allege is not until the check was received, again, we have no closing papers. These are all impounded. We're not allowed to see anything. We finally got a copy of the check from Crico, which has no amount on it. We believe it is $350, but there's no amount on it. The plaintiff, the defendant, Mr. Hicks, when he was alive, he was deposed. And he said he didn't even know what the settlement was, and the settlement was like 8 months before that. So we need to know an amount.
Why do you need to? You do the discovery on the contract case rather than a separate action like you filed in 2015.
We didn't do that, Your Honor. We wouldn't have, that would have meant, Your Honor, basically, although there would have been time after the settlement, that we would have been taking Mr. Grace's deposition while he was prosecuting the Dube case, the medical malpractice case, the Hicks case, Hicks-Dube.
But why can't you, even if you accept your idea that he has no money and he can't pay your legal fees, you can still bring suit and get some kind of contingent judgment if they recover or something. And also, the longer you wait, the more distant his memory is of what he actually did, and it becomes just a total guess about how much time he spent. You're entitled to that money, right? Right when he, walks off with the client, right?
We do not believe that, Your Honor. We were entitled, because this gentleman...
What is the language of your contract language says, right, that if the client wishes to discharge the law firm, the client shall in this event be liable to the law firm for a fee at the hourly rate of $350 per hour, as substantiated by a notary statement. It sounds like you're entitled to it right then and there.
Your Honor, all legal fees are subject to the general jurisdiction of the trial court. Mm-hmm. For the trial court to decide whether or not it's fair and reasonable, you have to know what the fee is.
Right, no, I understand that. But
versus...
you could have brought suit right then and determined the number of hours he worked on this case. Up to that point. And got a judgment, and then the damage, if he has no money, you could negotiate something, or the court could possibly, that it's related to the contingency.
You are correct, Your Honor. We could have done it. We did not. He chose not to do it because I did not want to mess up Mr. Dube's malpractice claim by doing discovery in the middle of the case. I would do it in the best interest of Mr. Hicks-Dube versus my best interest.
Why would that mess up Mr. Dube's malpractice case? That's totally separate. It's basically a case against you versus Mr. Grace, the one you brought.
Turns out it's not, with all due respect, Your Honor, it turns out it's not against Mr. Grace. because we didn't get a signed copy, and I've never seen an original, of the contingent fee agreement. It was not with Mr. Grace.
Doesn't matter what the new agreement is, you're entitled to be paid based on the old agreement.
Only if the court that's handling the case decides on the global fairness and reasonableness, we are entitled to it. And one of the issues, the key issues I think the court would consider would be the recovery that's received by the plaintiff.
But if Mr. Hicks, or if the client had lost,
We would collect nothing.
okay, but that's not what your agreement says. Does it?
It does not, Your Honor, but
So aren't you stuck with, I mean, it's one thing if you had said, if you prevail at a trial or
I
a
understand.
settlement,
It
then
does not say that, Your Honor.
that triggers it, and then arguably you would not be able to demand the money until the contingency had occurred, but you didn't do that.
correct.
So aren't you stuck with the fact that you did not include any contingency to trigger the obligation to pay?
I tried to, Your Honor, do this probably inartfully, totally, in the interest of the client. It did not, the client has a right to choose any counsel they want whenever they want it. The way this is handled today, I believe it's under the recommendations of the SJC, when there was a lawyer number one and lawyer number two, we'll call it, the contingent fee agreement, and mine didn't, and it doesn't apply, but the second fee agreement mentions who pays lawyer number one. Is that a fee above and beyond the contingency? I don't think so. I think that fee is included in the contingency. Otherwise, the client runs the risk of paying two fees. The contract fee, if you want to say it's a contract action, and a contingent fee, which is completely abhorrent to the statute and the statutory intent.
So are you saying if you had brought suit against your client, your ex-client, in, say, 2 years after the termination, that you wouldn't have been able to collect it because it was an unconscionable amount of money?
I don't know what I don't know what it was going to be, Your Honor.
You don't know? You couldn't have brought the suit?
I would have had to take Mr. Grace's deposition
Yes,
during the pendency of the case.
yes. But you're the one who wrote the contract.
Correct. I didn't think that was in the best interest of Mr. Hicks. The goal is what is in the best interest of the client, not only in selecting counsel, but also in advancing the underlying medical malpractice case. The goal was to collect money. Whether or not, how much of that money I got, I don't know. But I would be limited, much like a quantum merit, to an hourly fee, and we set forth what we would expect as a reasonable fee at that time. But
You're
Mr.
saying that the court wouldn't even entertain to understand what the right amount of money to award you would be until there was a settlement? You're saying
Correct,
the
Your
court-
Honor.
The court would not even look at this contract and say, well, you're not really, I can't say what the $350 an hour for whatever
Court-
number of hours, 88 hours that you originally alleged.
The court could do anything it want with my hourly rate. The court could do anything it wanted with the hours.
So it could have enforced the contract against your ex-client.
I believe that would be that would not be appropriate, Your Honor.
Well, not appropriate, but is it enforceable? Would it have been enforceable?
Well, it's a practical matter, no, Your Honor, and I chose not to enforce it. And I chose to do it if it was in the best interest of Mr. Hicks to advance his case.
But
That
if
was
you
the
wanted
purpose.
If you wanted the fee, I mean, and you mentioned that you wouldn't have sought the fee if you lost, but if you wanted the fee and you thought, well, I guess I think I'll only collect it if there's a settlement or a verdict, then you could have filed the suit, so the statute of limitations didn't run, and you're saying that the court wouldn't want discovery to go on and this to interfere with your client. You could have gone in and gotten a stay until that point. I mean, there's all sorts
Correct.
of things you could have done within the
Correct.
statute. You just can't stop, you can't just create your own statute of limitations. I don't think that's one of the things you can do.
But we're not doing that, Your Honor. Until the amount of the settlement or verdict or arbitration, whatever you want to call it, is resolved and there's an amount, then the court can consider what is a fair and reasonable fee. The appropriate way to handle this is when this matter was being closed, sometime in October of November 2012, when the check was received, which I believe is what even the canons of ethics have suggested, I think now may even be codified. the legal fee should have been put in escrow and then brought to the attention of the trial judge, the interests of all the lawyers that are involved, and the court can consider the totality of the fee and the expenses and how it should be divided. The court could have done that. The court was never given that opportunity. I didn't even know about the settlement till months after it
Mr.
happened.
Halstrom, isn't there a way of doing an attorney's lien?
There's a statute, Your Honor. We filed one for case costs, yes.
Did you file an attorney's lien? Did you file an attorney's lien?
For case costs, we did, Your Honor.
So you did. What about for the fee?
We didn't, Your Honor, but we filed the case costs 7 times. And instead of our name being put on the check, which really resulted in all of this being resolved within months of the settlement back in 12-13, Mr. Grace chose not to do that, or Dana Pellegrino chose not to do that. We now have the check, which we got in 17. We determined it went to Dana Pellegrino contingent fee agreement, not a contingent fee, the IOLTA account. And Dana Pellegrino distributed the funds. That was the appropriate way to be handled. That the court at the time, they also knew there was a claim that was going to be filed on contingent fee, on the hourly rate, because we made a claim on it. There was certainly no question where something was sprung on anybody. Mr. Hicks was deposed within 6 or 8 months of the settlement on the issue of fees. And as you may have read the comments in the footnote by the trial judge, what happened at that deposition. And if you look at what occurred, the court needed to know, how do you judge the totality of the fairness of the fee until there is a settlement? $35,000, $350,000, $3.5 million. It all kind of matters very heavily. So until the contingency occurs, this is a quantum merit mass, perhaps, some contract action, inside of a contingent fee. Contingent fee is governed by the statute. The goal is to reduce the fee for the plaintiff. Obviously, the goal is to discourage plaintiff lawyers from taking these cases. That was the reason why the statute was basically enacted. And to further the interests of Mr. Hicks in his malpractice case, not lawyers fighting about fees of a case where there is no fee to be realized at that time. So it's in the client's best interest that when the matter is resolved one way or the other, at that point.
But I would say that maybe that makes sense in the context where there's no attempt to create a poison pill. Your agreement says if you fire me, you're outside of the contingent fee arrangement. You owe me money, right?
That's what it says, Your Honor.
So I understand that if we just had no contract provision and you two were fighting over who's entitled to the contingency fee, we would wait. But you're saying, no, this isn't a contingency fee case. When you fire me, I'm owed hourly rate.
But again, we get back to, Your Honor, that the court handling the matter has the supervisory authority to decide whether that's crazy to do that. The court would wait.
Crazy or illegal?
I wouldn't use the word illegal, Your Honor, inappropriate. I think that the court would decide, well, let's see where the case ends up. And the attorney should be able to work this out. Not one attorney, number two, trying to you-know-what to attorney number one. That would be the normal way these things would be handled, except for the particularities of the relationship with Mr. Grace, who obviously was in his interest, is in his interest today, not to give any money to attorney number one. Poor Mr. Hicks is a defendant in this case, because that's who we have our contingent fee agreement with. But Your Honor is completely correct. The dispute is with the attorneys. Dana Pellegrino got the fee, got all of the money, not Mr. Grace. It was Dana Pellegrino. We only found that out when we got the back of the Crico check and found out where it was deposited. Mr. Grace said he had no idea when his deposition was taken, he had no idea where the money went. This is what we've been fighting. I mean, this is actually a ludicrous result of where we are now. If this matter had been brought to the attention of the trial court, where I had a lien on the case under the appropriate statute.
Of course.
Yes, but then obviously there was no surprise to Mr. Grace that there was a claim under the contract, contingency fee agreement, which is a contract for attorney's fees. He had the client sign it. But there's no surprise. At this case,
Could you have put an attorney's lien for the fees?
I did not at that point.
Would have.
I could have, I didn't, Your Honor.
Not.
Excuse me, Your
You
Honor?
did not.
I did not, because under my contract, I had to have I had to have some evidence what the hours were.
Okay.
And I don't have any hours. Again, that would cause me to depose Mr. Grace during the middle of the underlying case. I did not believe that would be in the best interest of Mr. Hicks. The supreme goal is the protection of Mr. Hicks and his rights. Once there is a recovery, then the lawyers can fight over what the fees should be and how they should be divided. But there should, in any case, only be one fee, the contingent fee, which is capped, not potential for two fees, one being a contract fee above and beyond the contingent fee. I think that would be a horrendous result. So I think the contingency happening, a recovery, that's the trigger for any claims against the Hicks estate. Now it's the estate. Even if we decided not to enforce the contract, we'd have a quantum merit. And on the equities of this, I don't know if you want to hear about the equities or just the statutes. I'm under time, so I don't know what you want me to do.
Mr.
Excuse me, Your Honor?
I think your time is more than up, Mr. Halstrom. So
Thank you very much
we
for
will
your time, Your Honor.
evaluate the equities on the record and on the briefs.
Thank you, Your Honor.
And we'll hear from Mr. Grace, I expect, on that issue.
Thank you, and good afternoon. Michael Grace for the defendants, Appellees, Marilyn Dube, and myself. I just want to correct a couple things that Mr. Halstrom said erroneously. One, I did not say I didn't know where the money went. There was a protective order entered by Judge Brieger on motion by Crico, the med-mal insurer. I didn't tell Crico to file a motion for a protective order. I don't care who knows about the settlement, and if this court wants to order me to tell them what happened to the money, I'd be happy to do that. And I forget what else he said, but
What do you understand, what do you understand
this is
to
the
be
fifth
at-
lawsuit he's filed against me
what do
since
you
he fired
understand
me
to-
8.5 years ago.
What do you understand to be at stake in this?
Pardon?
What do you understand to be at stake in this litigation? What kind of money, is it fees, is it costs, is it what?
Fees. Mr. Halstrom filed a claim for costs too. In his lien letters, 8 lien letters were double what he actually paid. He was reimbursed in July of 2013 for what he actually paid.
In costs?
Yes.
So costs are not an issue anymore?
Well, he says he's owed another $15,000 or $13,000.
What kind of fees
About
are we talking
$16,000.
about?
Okay. Is the court ordering me to,
I'm not
I'd
gonna order
welcome that, to
No.
discuss the settlement, 'cause I don't care. And-
We're not ordering you this orally, so if we do so, we'll do it in writing.
Okay.
Let me ask you this.
I'd be happy to
If
answer
the-
that question.
Okay, well, if we do so, as I say, we're not going to give oral orders to
Okay.
do things. We'll do it in writing if we decide to do that. If the agreement had said that upon discharge, you will owe $350 per hour, but that will be collected only if you prevail with regard to your lawsuit and recover either at trial or pursuant to a settlement, would you agree that the date in which the statute begins to run is the date of the contingency?
Not necessarily, but much more likely than the way it was actually drafted. We're dealing with what was actually drafted, which is clear, unequivocal, coercive, and if it's ambiguous at all, it has to be construed against him. Now, from this day forward, or after the rules of professional conduct and the comments changed, a contingent fee agreement either should be drafted such as that, or I think it will be, language will be implied to that effect. But this agreement and the Denner Pellegrino agreement were before the changes to the rules that went into effect in March 2011.
Let me ask you, what would have happened if the statute of limitations had not run? If the statute of limitations had not run, what would the rights be? What would your arguments be? Assume that the statute of limitations has not run. Or we
Right
would
now?
Right. Then,
Oh, on his claim against me and the
Yes.
estate for
Yes.
fees?
yes.
Oh, that's easy. I wasn't paid a penny for any of the work I did there. Nobody, well, not any of the work, but the cases I did on the the work I did on the cases that I originated, such as Hicks and about 7 or 8 other cases, all of whom came with me. So it'd be unjust enrichment if he got a penny for any fees, because I did all the work and
But if
wasn't
you
paid for it.
take Justice Link's hypothetical and add, if you'd stayed at the firm, say you'd stayed at the firm and they went and hired someone else,
Yes.
so would you and Mr. Halstrom, imagine you on the same side for a second.
Hard to believe,
But if you were stayed at the firm, would you be entitled to collect a certain amount of money even though you hadn't been paid anything for it?
I wouldn't have, the firm might have. I wasn't part of the contract, no. I
No.
would not have.
But the firm would have been entitled to some money then.
Well, according to the contract, yes.
Right.
Yes.
So then, and I don't mean to cut Justice Link off.
No,
so-
go ahead,
yeah.
Justice Gasper.
So then, if that's the case, you're leaving it as a matter of the pure contract doesn't really matter, does it? You've left, I understand you've left, but you say Mr. Halstrom would be entitled to money had you stayed, right? Under that existing
If-
contract, even though you hadn't been paid anything, he'd be entitled to money, right?
Oh, well, if he got paid, I would be entitled to a percentage of it. We had an oral agreement.
That's not my question. I'm just trying to, what you do is, he sues you, and you don't give him the information he's looking for.
Yeah.
And I understand that, but if you had stayed, he'd be entitled to this money, but then you're not cooperating with him, and that prevents him from getting any money. The statute of limitations may have expired, but I'm working from Justice Lank's questioning, which is, if the statute of limitations not expired, then he's entitled to some money, right?
If the firm was discharged, I don't think I got the full hypothetical.
Okay. Well,
Do you mean if the firm was discharged and
yeah, I mean, if
went on to collect
They
something
went
by
to- they
settlement
didn't-
or judgment?
they hired some other
Right.
firm. It looked like the contract entitled Mr. Halstrom's HLO to get paid. Was that illegal, that provision?
No, but let me amend my answer. If he got paid, if Mr. Halstrom got paid for a case that I brought in and I did the work on it, then yes, I would be entitled to some.
Yeah, I'm not worried about you. I'm worried about him for a second. If you had stayed with him, you would have been, the HLO would have been entitled to money, but you leave. Right? That shouldn't matter, right? Or does it matter? I guess I'm confusing you.
Yes, you are confused. I've listened to more than 3 hours of criminal arguments, yes. I haven't had lunch, yes. Yeah, I am confused.
That's no excuse for us, I'm afraid.
The point is, whether you're there or you're not there, if it's a contract and the firm has a right to collect on the contract, that right exists whether you stay or whether you leave. Now, the reality may be that the firm may not have done anything if the contract says that the firm's entitled to the attorney's fees, if the client leaves, then the firm's entitled to the fees.
Yes. And the cause of action accrues right when the client discharges the firm. It doesn't occur at some future date.
Okay, so suppose that lawsuit was filed. Suppose that Mr. Halstrom filed a lawsuit against your former client, or the deceased client, Mr. Hicks, and it says, I want $350 an hour for the time that we worked here. Suppose he could in fact have put together a notarized statement of hours that would have been reasonably accurate, and that would have been brought, well, let's say within a year of having left the firm. Isn't there a problem when you come down to how do you distribute the settlement?
Not a problem that can't be worked out. Yeah, there are certainly issues there. Yeah.
How does it
And
work?
there'd also be an issue whether he'd actually, Halstrom would be entitled to any of the money. He could claim it, but in these circumstances. And
Would
with
you
the-
have two lawsuits? You have your malpractice suit going on on behalf of Mr. Hicks. That would be the judge who decide what the attorney's fees distribution?
Yes.
That would be a different lawsuit.
It could be, yes, or it could be a judge in a companion case that was filed.
But it would be the malpractice suit that would be the arena for the determination of what fair attorney's fees would be.
Probably the most appropriate.
So if Mr. Halston brought a lawsuit to enforce his contract, and it was pending at the same time as the malpractice action, it would be under a different judge presumably, or maybe there would have been
Probably
consolidation of the
consolidate
cases.
them, yes.
So that's
That
how it
makes
would
sense.
work. That's how it would work.
I would think so, yes. I've never encountered that, but yes.
So there would be some entitlement at that point to have Mr. Halston get some money, or no?
No, not necessarily, no.
Because he did some work in the
No,
sense
he
that,
did
no,
not.
I
He
don't
didn't-
care
he
about,
didn't do any
I
work
don't
on
care
this
about whether it
case.
was he personally, it was his
Pardon?
firm. His firm did
Right.
some work, and they're not compensated for it. How come?
Because he didn't compensate the only lawyer who worked on the case 1 penny for any of the work he did, so that's why he wouldn't be entitled
But
to
he has an
anything.
entitlement under the contract to fees because it was done under his aegis, under his office. You were working for him, you were his employee, right?
Right, yes.
So it was his right to collect the fees.
Yes, subject to defenses, right.
Okay.
Unless there are any more questions, I'd waive the rest of my time.
Okay, thank you.
Thank you.
All right.